Its docket. That is case number 105183, State v. Moyer.
May it please the court, my name is Robert A. Anderson Sr., Ellenwood, Kansas. I am the court-appointed attorney for Steve Kelly Moyer, the appellant in this case. Mr. Moyer was convicted by a jury trial back in 2010 from charges he received in 2009, and he appeals trial errors. With the 15 minutes that were given to oral argument, I asked for 2 minutes to be reserved. I certainly don't have time to cover all 10 errors that I listed in my brief, but I would like to address 3 or 4 of those. Did you want a fact pattern for the?
If you can keep it not too graphic, that would be greatly appreciated.
Okay. Your Honor, I was not the trial attorney for Mr. Moyer, but Mr. Moyer was arrested in 2009, April. He was assigned a court-appointed attorney who, by virtue of the appointment list in that judicial district, was not qualified to handle the type of case. Mr. Moyer was charged with 5 sex crimes in 2009. Each one of those was on the grid at the time. The Attorney General stepped in and took over the case. About a month later, they amended the complaint and charged Mr. Moyer with 3 off-grid felonies, which the court-appointed attorney for Mr. Moyer was clearly not qualified to handle. The district court judge in this case that was assigned the case was a recent elected judge. That son was a part of the arresting party that arrested my client, Mr. Moyer. In the course of pretrial motions, a motion to recluse was filed pursuant to state statute. That was denied by the district court judge. And while the record would suggest from the transcripts that the court-appointed attorney followed the KSA 2311 statute and filed an affidavit, if you look at Exhibit 1A in the appellant's brief, the letter from the chief judge of that particular judicial district and of that Sherman County Court says he can't recall whether he ruled on a affidavit, whether he saw one, whether it was heard, but it's pretty apparent that the second phase, the affidavit under that statute, was never complied with. And that's one of the issues. Like I said, Mr. Moyer was convicted of 5 sex offenses, given a life sentence, plus additional months, mandatory minimum 25 years to serve before he's even eligible for parole or starts to serve the other part of that sentence. Mr. Moyer is appealing trial errors. And the first of those trial errors is the fact that the judge had an absolute duty to recluse himself, where his son was a member of the arresting party that arrested Mr. Moyer. His son was listed by the Attorney General in the amended complaint as a witness. And the way the district court judge tried to cure this was said, well, we'll just take my son's name off the witness list and he won't be a witness. Well, as I pointed out in my brief, that certainly doesn't do Mr. Moyer due process rights and constitutional rights that he has to have a fair trial in the state of Kansas. And for all the reasons cited in the brief concerning that, the judge should have stepped aside and had someone else hear this case.
Well, there was more, was there not?
I'm sorry, Your Honor.
There was more, was there not? The judge also excised any mention of the son's name in any of the documents. So when they tried the case, there couldn't have been an appearance of impropriety because his name didn't appear anywhere in the proceeding.
You're absolutely correct, Your Honor, that that's what happened, but that doesn't take away the bias, the potential for bias by a sitting judge whose son was a part of the arresting party, who's still employed by the law enforcement agency that arrested Mr. Moyer.
My problem with that argument is our case law, which, as I read it, I mean, we have cases where a family member is part of the county attorney's office, maybe not, I mean, clearly not trying the case that's in front of the judge, but part of the prosecution's office, and we've said that's all right. So without trying to distinguish that, what case is your best case
Well, Your Honor,
to convince me that this judge should have recused and that it was structural error and that the conviction should be reversed?
Your Honor, I would cite this court's decision from 2012, State versus Robinson, 293 Can 1002, and that's where it says if the risk of bias is too high, it is not constitutionally tolerable. And that's exactly what the facts of this case and what happened in this case should be.
How is the risk too high?
Because you have a district court judge, newly elected judge, that's never had this type of a jury trial before. By his own admission in the record, I'm just citing from the record, this was his second jury trial. You have an off-grid felony. I cite in the brief, and I don't want to read that into the record, but the court's seen that, and I know you've reviewed the brief, is the statement that the court made during the defense counsel's third motion in limine, in the statement about, well, we have a molehill problem here and a mountain of evidence. He hadn't heard one bit of evidence of the defense side of the case, and he's making a statement on the record that there's a mountain of evidence in this case. And he was going to correct that by taking his son's name off the witness list and redacting and everything, the rest of the case. So at that point in time, and if you look at all the other rulings in this case by the district court, assignment of an unqualified court-appointed counsel to Mr. Moyer, and Mr. Moyer filed 3 separate motions to fire his court-appointed counsel before it even got to the jury trial, 2 of which the district court judge never held a meaningful hearing or any hearing. On the one hearing that he did hear, he told my client, told Mr. Moyer, that there's only a handful of qualified attorneys in this whole part of the state that could handle this type of case, and you have one of them. But if you look at Exhibit A1 in the brief, the court-appointed counsel that was appointed to Mr. Moyer's case was only qualified to handle up to a level 5 on the felonies.
Can we look at Exhibit A1? Was it a part of the record before the district court?
Well, Your Honor, I filed a separate motion to have that to be an exhibit, and it was granted by this court or the clerk's office that it can be a part of this. I will tell you that A2, which I had marked in the brief, it was determined that that could not be considered, it could not be a part. But A1, which is the letter from the chief judge of the Sherman County District Court to include the Board of Indigent Defense or the attorneys that are qualified to handle the various cases, that is a part of A1.
But my question specifically was it a part of the record before the district court?
No, absolutely not. It wasn't a part
You
of the
have
record.
added that.
And that was one of the issues and one of the problems. Mr. Moyer was told that his court-appointed attorney was qualified, and that was never raised, never.
Is there a procedural mechanism that would allow us to consider that? I understand it's an exhibit now, but
Yeah.
is there any basis for us to consider something that wasn't a part of the record before the district court?
Well, Your Honor, procedurally, I'm not really sure about that. I know that this court in the past has remanded cases back to the district court for a hearing on issues such as that. And the third issue that I'll eventually get to, that's one of the remedies that the Kansas Supreme Court has done in other similar cases, remanded it back for a hearing on that issue.
So this would be part of what you would present if we did have a Van Cleef hearing?
Well, I'm not even referring to the Van Cleef hearing, Your Honor.
Okay.
I do make that as my 10th issue, that if none of the other issues bring reversible error by this body, then I think the court could remand this back to the district court for a Van Cleef hearing on ineffective assistance of counsel. But on the third issue here, where I talk about the fact that the judge never conducted a meaningful hearing, this court has remanded, I believe, State versus Van, 290 Can 782. It's a 2006 case. This body remanded the case back to the district court for a hearing on the issue of whether or not there was a meaningful hearing conducted by the district court. This court clearly states that it's required of a district court judge when there's a conflict of interest or when there is an issue, there should have been a meaningful hearing. But if the record doesn't reflect that there was, the court has that option to remand the case back to the district court for that issue.
And you're saying that the conflict was the lack of qualification?
Well, that's one of the issues in this case, but I haven't brought it up. I was responding to the Justice's question is what other issues were there concerning the conflict and the issue, what was the bias on the district court judge. I was just saying that everything that I've listed in my brief points to those things, and that's one of the issues is the fact that you had an unqualified, according to their own records at the Sherman County District Court, court-appointed attorney that was appointed before it was while it was a grid offense, and now it's an off-grid offense, which is even more serious. And at that point in time, a month later, and that was during the time that Mr. Moyer was filing pro se motions to request a change of attorney. He did not want his court-appointed attorney, and at that point in time, something should have been done. The motion to have the judge recluse himself, that was never the one hearing that was held. He refused to recluse himself, and then while the court-appointed attorney states on the transcript that, yes, I followed the statute, I did file an affidavit, there's nothing in the record would support that. Clearly, that's something that should have been done. And then, in addition, which kind of answers Justice's question here, you have a situation where the court-appointed attorney for Mr. Moyer was later, several months later, during the pendency of this case, before it went to jury trial, he was appointed as a guardian ad litem, which he clearly was qualified to handle, for a young woman, initials JT. Turns out that this particular person he was the guardian ad litem for, JT, had been in the Moyer home on several occasions, had talked to the alleged victim and the victim's sister on numerous occasions, and had reported to the court-appointed attorney for Mr. Moyer that, oh yeah, those stuff that my father was charged with, that didn't happen. We made that up. When it comes time for the jury trial, on the fourth day of the jury trial, there's a court-appointed attorney asks the judge to go in chambers. They go back in chambers and says, well, Your Honor, I've got a problem here. I represent somebody as a guardian ad litem. I tried to get her subpoenaed. She didn't get served, but we need her to testify because she's crucial to my client's case. And at that point, there's a colloquy in there that I put in the brief, and I won't go into details on that, but that the court-appointed attorney told the judge that he had known about this for 2 months, didn't get the witness properly subpoenaed, and she was at some facility where there was a question about whether she'd be a flight risk or whether she could come. But at that point in time, there should have been a request for a continuance. Something else should have happened in this case at that point in time, but there should have also been,
Excuse
and
me,
I cite
counsel?
to the record.
Counsel, excuse me.
Yes.
There was also a fairly significant question about whether any testimony would be competent. Isn't that correct?
There was an issue as to whether at that particular time, because her location at a particular facility, whether it would be competent. And that's why I'm suggesting, Your Honor, that there should have been a request for continuance, a request for a mistrial, any number of things at that point in time, rather than proceed with a jury trial on this serious of a case where this is a key, crucial witness to Mr. Moyer's defense.
But by the end of the same day, hadn't your client agreed that it wouldn't do to call this witness because of the competence issue?
Well, Your Honor, that's accurate, but there was never a waiver signed, which would have been required. The record would reflect that the judge, district court judge, asked Mr. Moyer and his attorney in chambers or even in the courtroom, absent with the jury, you know, this is what's going to happen. Do you agree to this? Well, Mr. Moyer agreed that he wanted to have the trial, but he never agreed not to have JT as a witness in his case in chief. I wasn't there. I only know what the cold, dispassionate record shows. But clearly, there was no waiver signed by JT. There was no waiver signed by my client, which would have needed to be signed. And then, Your Honor, in regards to the next issue, there was a redacted.
Pardon me, counsel.
Yes.
You're 2 minutes over the time you had requested to be allotted. Would you like a minute to wrap up?
I would, Your Honor. The two other issues that are very important, should get reversible error and allow Mr. Moyer to have a new trial, is that the court, both counsel approved of a CD that was a redacted version of the interview of the alleged victim, the St. Sark interview. The law enforcement officer that was working for the court gave the jury the unredacted version. And the jury saw this unredacted version to include all of the prejudicial testimony, all of the things that the court already agreed should not be introduced to the jury. And by the time it became aware that this was occurring, the defense attorney requested a mistrial, and the district court judge says, no, we're not going to have a mistrial. I'll just tell the jury to disregard the stuff that they watched that they should have never seen. It should have never been presented in this case. And the only other thing is, Your Honor, the prosecutor, one of the attorney generals, offered in the closing arguments her own evidence or suggestion that the evidence was so strong, and it's a prosecutorial misconduct issue, which I've raised, and clearly this court has ruled in other cases where a prosecutor cannot inject into arguments their belief that evidence is so strong. What she said in this case was, and there's so much collaborating evidence in this case, but there always is in these type of cases. And I've cited in the brief.
On the unredacted version that the jury heard about 3 of the portions that were supposed to be excluded.
Absolutely.
But wasn't there other evidence throughout the trial that basically established those 3 things that the jury shouldn't have heard through the review?
Your Honor, I can't answer that. I don't know. I wasn't the trial attorney. I've read the entire 23-volume record very closely, but I can't answer.
Well, there was some evidence in the unredacted version that talked about threats and killing the victim, and then there was other evidence at trial that was adduced through other witnesses that suggested the same kind of evidence. And I'm wondering what kind of impact that has on your claimed error as far as the redacted.
Well, Your Honor, I apologize, but I just don't know
Okay,
that.
thank you.
Okay,
Thank you, counsel.
thank you.
May it please the court, the state appears by Assistant Solicitor General Natalie Chalmers. Sorry, I have a cold, so my voice might be going. On the judge's recusal, there was absolutely no reason for this judge to recuse once his son was no longer going to be a witness and his name was stricken from being referred to at all in the trial. I don't think there even was a conflict of interest with the sync witness, but if there was, he has certainly not proven. Sorry.
Let's back up here on the sync witness and the potential conflict. Is there a conflict here between, he represents a witness, a sync client that he's representing and concerned about the welfare of this particular client, who has disclosed important information regarding his client in the case that's before us today. So there's this kind of dual kind of role happening where he represents a young woman in a sync case who's vulnerable, discloses certain things that's important to his client Moyer's defense, and he then makes a judgment about whether she should testify or not. And I can't imagine there's not a conflict that's between what's in the best interest of his client, defendant Moyer in this case, and the welfare of his sync client. I mean, if he chooses to say, no, I'm going to demand her presence, I want a delay, I want her here, it's putting her perhaps fragile state at stake. She's in a psychiatric facility. She's subject to not only on direct examination, what was told to her, but then probably pretty grueling cross-examination from the prosecutor about her competence. And it just seems to me that's a conflict, and I don't know how you get yourself out of that conflict.
It's a problem any attorney would have with this witness. This witness was not competent or didn't appear to be competent. She was a danger to men, which would make her a danger to the defendant, presumably. There was no reasonable attorney that would have called this witness. Even if there is a conflict, I don't see how prejudice can be established.
How do we know that there's no reasonable attorney that wouldn't have called? I mean, there's no record. Did the judge make findings about this issue?
I believe what happened on the record is there was an in-depth conversation about what steps he had taken to determine whether or not she would be able to testify. And he stated multiple times that the doctors advised against it. And there was a question as to her competency. And eventually he made a judgment call and said, this witness shouldn't testify. The court turned to his client and said, do you agree with that? And he said, yes.
And so we're to take a counsel who has a potential conflict advice to the fact that he gave advice to his second client, and that's supposed to be sufficient advice? Shouldn't there have been conflict-free advice? I mean, doesn't Mr. Moyer have the right to have conflict-free advice about whether this witness should have been subpoenaed and called or not?
He does have the right to conflict-free. But in order for there to be a reversible error, he has to prove that he was prejudiced by that conflict. This does not, to me, rise to the level of an actual conflict here. What the witness's problem and the defendant's problem are one and the same. She's not a good witness right now.
That was the day of trial, but the knowledge was obtained 2 months earlier. Is there any evidence that she was disqualified to be a witness when defense counsel, her guardian ad litem, interviewed her and obtained that evidence?
Not that I'm aware of.
Well, then, at that point, why wasn't there a conflict arise at that point?
Because at that point, she was willing to be a witness. There was no problem with her testifying.
At that point, she was going to be helpful to the defense.
Right.
The conflict develops when her competence comes into question.
Right, which has nothing to do with anything the defense did. It's outside factors based on apparently a frail mental child.
But you do see a conflict between acting as a guardian ad litem for a vulnerable individual and having to protect that person's rights when they're in a vulnerable situation or a situation where they're vulnerable, on the one hand. And as my colleague Justice Rosen suggested, a grilling by the state is probably not going to increase the chances of her mental health recovery. Would you say that's common sense?
Yes.
Okay. That is in conflict with bringing her in to offer this exculpatory testimony for the defendant. Those two things are in conflict, are they not?
It would be a potential conflict, but it's also, regardless of him being the guardian ad litem, I can't see any attorney saying this person has serious competency questions, has been told by multiple doctors you shouldn't testify. Why any attorney would put her on, especially when the evidence completely conflicts with everything she's going to testify to.
But, Counselor, that misses the point. The point is, shouldn't this defendant have had an attorney without a conflict to tell him that? To tell him, I advise against calling this witness. I mean, that's the point we're trying to get at here. It's not whether she would have been a good witness, but whether the decision to call her was pursuant to conflict-free advice.
And again, I don't think the conflict, I don't see him doing anything to protect his guardian ad litem's client in this particular record. He seems to be solely concerned with Mr. Moyer. He is not calling her to protect her interest. He's not calling her because she's not a competent witness and would not be helpful to Mr. Moyer's defense.
But that's the whole point. We can't know. When you have divided loyalties in that situation, you say he's not looking out for her, but how do we know that?
I'm not sure, but at that point, it becomes a theoretical division to me.
Well,
It's
and
not,
that's why we do not allow attorneys with conflicts to have dual representation at the same time, because we can't know which master they're serving.
but this doesn't reach the level, I don't think, of an actual conflict. There's not, I think it's at most a theoretical division of loyalty, and he still has to prove prejudice. He can't here. Or he has to prove somehow that counsel's representation was affected, and here counsel made the right call.
That day, let's return to the idea of the timing. Defense counsel was aware that he had this dual representation for, how long does the record reflect?
I don't remember off the top of my head,
I
I'm
mean,
sorry.
he'd been appointed a couple of months at least, I think, before the trial. He'd become aware of the testimony, the potential testimony at what point? Can you remember that?
It does say in the record, I don't remember. I think a few months before the trial.
That's what I thought too. That's what I seem to remember. And that's what's troubling to me, because there are ways of preserving her testimony at that time even. If he had any worries about her mental health at any point, he could have gotten out there and gotten her testimony, sworn testimony recorded, couldn't he? And this is troubling, because there is, to me, an obvious conflict between his responsibilities to the two clients, two simultaneous clients. Not because of the nature of the testimony she was going to give, that actually put them in alignment, but because of her vulnerability.
I don't know that he knew she was vulnerable at the time. He certainly didn't take any actions that would suggest that he
And then the
thought she was
question
vulnerable.
becomes, should he have been keeping track of that? I mean, I just think that you have some issues about whether there should have been more diligence in terms of monitoring this critical witness. I mean, she had critical testimony, potentially critical testimony to give about admitted untruthfulness on the part of the victim.
I think before this court, if there is a problem, before this court reverses, it should be a remand to figure out if this was an actual division of loyalties, what he was doing here. If you need more facts, then I think a remand is appropriate.
Because I think your position in your brief was that we didn't need a Van Cleve, but you're saying now possibly that would be the resolution that you would prefer.
Well, yes, I do think I said that I don't think there is, but if this court disagrees, the Van Cleve or 1507 proceeding would be appropriate.
I need you to convince me on one thing you've said, which bears on this question of whether we need to send this back. You've said that no reasonable attorney would call this woman to testify, this young woman to testify. And how do we know that? And my problem is that everything we know about what's going on is the conflicted attorney telling the trial judge what he learned through telephone calls or his partner's telephone calls with the hospital, correct?
Correct.
So, and how does the district court make a determination? I mean, we've got I think there's let me just say, I think there's a conflicted lawyer here. Two different clients, and they both play a role in the case. So let's start with that. But how can that court or this court on appeal accept the factual circumstances that may exist about this person when all we have is the one lawyer, the conflicted lawyer, making representations about it?
And then if you need more facts, then a Van Cleve would be appropriate where actual evidence could be put on besides the counsel's testimony regarding what he knew, even though his client said that he agreed not to call this person.
Okay.
Who would be the?
That's your safe harbor. I understand that's your safe harbor argument to save your case at this point. But I'm trying to get at whether we need to go there. Do we need to remand this? And I guess I'm asking you to convince me that we don't need to remand it, that somehow we can accept the representations of this lawyer through hearsay and repeating what other people have said about what the condition of this witness is. I don't see how we do that.
The trial counsel does have a duty of candor to the court. Presumably, he's not making this all up in order to get this client of his that he apparently hadn't talked to. And I think the Sink case might have terminated by the time this trial happened, so I'm not even sure she was still his client. I lost my train of thought. But I don't think we should assume that counsel is just making things up just to get out of this witness
No,
testifying.
I don't want to assume that either, but it seems like to come to the conclusion that you've asked us to come to, which is that no reasonable attorney would do this, we need concrete facts. And I'm just trying to see whether you've got an argument based on what we know that we can go ahead and jump to the conclusion that no reasonable attorney would have called this witness.
What we know is what counsel said, that he repeatedly contacted the person and that the doctors strongly advised against it and almost seemed like they would not willingly let her, and that she was in psychiatric hold of some kind.
She
It
was
was a
being
danger to life.
transported. I think she
I'm
was going to
sorry?
be transported that day to an inpatient facility or a locked ward. And as I recall, it was a doctor. You said doctors a couple of times. Do you remember
Oh.
more than one?
It may have just been a doctor. I think it was the doctors, and I'm calling the
For
nurses
treating.
doctors. Yes, sorry.
Yeah. Okay.
Counsel, if we do send this back for a Van Cleve hearing, do you have an opinion on whether this same district judge can handle that hearing, or does it need to be somebody else?
I don't see any reason why the district court judge wouldn't be able to handle this hearing. Usually Van Cleves are done by the original trial court judge. He is way more familiar with the facts than any of the parties arguing today. I think he's perfectly appropriate if he so chooses to hold this Van Cleve hearing,
All right, thank you.
if there is one.
Would you agree that it was error to give the jury that unredacted video?
Yes.
Okay. Would you agree that a unanimity instruction was called for? I think it was on count 2, where the evidence was that there were 2 acts of the same particular crime on the same day, or the victim said 2 acts.
Yes.
And would you agree that the limiting instruction included some of the material facts at the time that were not called for? I know you're arguing now that it's harmless error because you can use propensity, but didn't it list identity as one of the reasons for
It
this?
did list identity, yes.
Okay.
I don't think
And so if we determine those 3 errors and say we disagree with you about the dual representation, then we've got 4 errors here and that's not even counting the prosecutorial misconduct. I think you agreed that the facts not in evidence was error. So that brings it to 5 errors. So explain to me why we don't get into the prosecutor misconduct was saying that we always have abundant evidence in these kind of cases. Corroborating. And I thought you conceded that that was.
Oh,
fact.
I did concede that that statement was outside of evidence, yes.
Well, explain to me then, or give me your best argument when we start counting these up. One of the issues is cumulative error. At what point do the errors accumulate to be a denial of a fair trial?
Here, the evidence in this case was overwhelming. As on count 2, if you say there's a unanimity instruction and it's not harmless, we lose that count. That doesn't affect any of the other counts, it's isolated. The prosecutor misconduct, there's no ill will, it's not gross and flagrant.
Yeah, I know your arguments on
Right.
each one of these is why they're individually harmless, but we still have to put them together and look to see whether the cumulative effect denied the
Correct.
fair trial.
But the prosecutor misconduct in this case went against the state's case. It's not true that there are this much corroborating evidence in sex cases. This is unusually corroborated case. So I don't see how that factors into cumulative error because it doesn't hurt them. As to the sending back the tape, again, it's an isolated error. I just don't think that they overlap in any way to deny Mr. Moyer his right to a fair trial.
Ms. Chalmers, my colleague asked about the unredacted tape. He asked opposing counsel about whether the evidence had not come in other ways. Can you address that?
I don't know that the exact same evidence came in, but there was an evidence that Moyer had threatened to kill the victim in this case. And the evidence on the tape was that he'd also threatened to kill the mother.
Okay.
Which if he's threatened to kill someone, I don't see how threatening to kill the mother. And then just, there is, he's also talking about evidence that the sister was thrown down the stairs and then a pop can was thrown. Was the evidence that he has pointed out in his brief that was in the unredacted tape. And to me, that just pales wholly in comparison to the evidence that was admitted in this case.
Okay.
So
I think that's two. I think maybe there were three things. I can't remember the
I
third right now.
don't
either.
remember
Okay.
the third thing.
Okay, thank you.
Counsel, you're out of time. Would you like a minute to wrap up?
The state would respectfully request that you confirm Mr. Moyer's convictions based on the overwhelming evidence in this case. Thank you.
Do we have any more questions? Thank you, counsel. You reserve 2 minutes for rebuttal.
Your Honor, first, where counsel's talking about allegedly overwhelming evidence, clearly an appellate court will not reweigh the evidence, pass on the credibility of witnesses, or resolve conflicts in the evidence, citing this court's In re Williams 292 Can 104 and that 2011 case. That's the reason I didn't address the evidence, but trial errors is what I addressed.
But counsel, she's talking about harmlessness, overall harmlessness
I
and cumulative
understand, Your
error.
Honor, that, but I think in this forum that I want to make sure that the reason I'm not addressing any of the evidence other than the trial errors is for that reason, that the court's not going to consider any of that anyway. All right. Several different justices asked questions. I started to write the names, but I'll address them all. Here's what happened in this case. April 9th, 2009, the court-appointed counsel was appointed as the defendant's, Mr. Moyer's attorney. On December 4th, approximately 8 months later, he was appointed as a GAL for JT. On January 11th, which was less than 1 month later, he was told by JT what I already told the court. At that point, when we started talking, or counsel was arguing about it, no reasonable attorney would do this and do that. I would make this statement. No reasonable attorney that understands the ethical obligations, that understands legal malpractice, would have done anything other than on January the 11th, 2010, when he got this information, if it was still part of the day was left, I would be in the judge's chambers with a representative of the Attorney General's office that I've got a problem. I've got to withdraw as Mr. Moyer's attorney. You have to appoint somebody else to represent him. I have to withdraw as JT's attorney. I cannot represent her. I may or may not be a witness in both of these or whatever, but I certainly cannot represent both of these individuals. And that would have been in January of 2010.
Do you know what the basis for the guardian ad litem appointment was? What was it, a juvenile case? It's sent from a domestic case? Do you know? I don't know that it matters. I'm just,
Your Honor, I've heard bits and pieces, but I don't know enough to give an opinion to the court. It was certainly a child in need of care case.
Right.
And it was involving some issue with JT and her father. Almost, as I was told, and the record would somewhat reflect that, similar allegations in nature.
Similar to JM and her father,
Yeah,
and similar
yeah.
to JT and her father.
Absolutely,
Okay,
Your Honor, that's
thank
what
you.
there was. But what I'm submitting to the court is on January 11th, he should have withdrawn from both cases. The jury trial could have been postponed because the jury trial started in February. February 4th is when, for the first time, the court-appointed counsel for Mr. Moyer goes to the judge in chambers at the fourth day of the trial and says, well, I didn't get the subpoena served, and by the way, I might have a conflict. And the district court judge at that point in time says, well, if there's a problem here, and it appears there might be, that's for some other body to determine, referring to this court or referring to whatever. But your decisions, the Kansas Supreme Court's decisions on these type of cases where there's a conflict, require a district court judge to make a meaningful inquiry at that point in time, and that's what should have happened in this case, and it didn't happen. And thank you, Your Honors, for allowing me to be here today.
Counsel, I have
I'll
one
ask you-
follow-up question. I'm sorry.
Go ahead.
I think I understand that you are making every effort to be sensitive to the forum, and I think I appreciate that. I'm sure the court appreciates that. But keeping that in mind, I'm going to redirect you, if I can,
Absolutely.
back to the harmlessness analysis and the question of whether or not there's prejudice, and ask you to really respond to the state's argument that the evidence against your client here was overwhelming. And so why isn't the evidence overwhelming? Because we have the statements of the victim, we have the testimony, we have audio recordings, we have these written contracts, we have a lot of evidence.
Well, Your Honor, obviously, can I address that?
I'm asking you to, yes.
Absolutely, I'd love to, and I'll try and make it as brief as possible. And once again, I wasn't the trial attorney in this case. But one of the issues raised was the fact that the defendant was denied the opportunity for independent medical examination of the alleged victim, which should have been done and wasn't done. And that's one area when you talk about overwhelming evidence. There was an expert witness obtained by the court-appointed attorney, but he didn't get that particular witness subpoenaed, so they had to do that particular expert witnesses by video deposition, which should have been live testimony. That would have disputed a lot of the evidence. The evidence in this case, as I understand it, you have JT telling the court-appointed attorney that, no, I was at the defendant's house, I talked to both daughters told me that none of that that's been alleged against her father ever occurred, that this was all made up. That's the overwhelming evidence that never got before the court, that should have got before the court. So when counsel would suggest in the record and the stuff that was omitted in the evidence, is it overwhelming? Yes, there is a lot of evidence. But the evidence was not presented as it should have been. JT's testimony wasn't taken, it wasn't preserved. That's another thing that should have been done back in January, was a videotape deposition by another attorney, not by the court-appointed attorney because of the conflict, but something should have been done to preserve that. There was all sorts of things that were not done in this case by an attorney that clearly was not qualified to handle an off-grid felony. So to say that the evidence that was presented in this case by the Attorney General's office is overwhelming begs the question of what would a competent, qualified court-appointed attorney done in this case?
And the thing that you're pointing to, and it's the only thing I've heard, and I want to hear if there's other things, is the proffered statements of JT. Is there anything else that you're going to advocate goes on the other side of that scale
Yes, the fact that the defense was denied the opportunity to have an independent examination of the alleged victim. There
was expert testimony offered at trial by the defense that disputed some of the findings of their expert, wasn't there?
That, Your Honor, that's correct. And that was based upon that expert viewing slides and pictures from the state's expert, not being able to conduct an independent medical exam of the alleged victim, who was clearly old enough to have went through an exam. But that's one of the other areas. I would have to refer to my brief. I know there was 10 different issues I raised, but I don't believe that the allegation that the evidence was overwhelming would rise to the level of the biasness that's in this case that would not cause this court to grant Mr. Moyer a new trial. Clearly, there's cumulative error, and when you have cumulative error, and what this court has said in the past was you might have error in one case, but it not be strong enough, or the evidence in the case is so strong that, plain error would not be enough to grant a new trial. But when you start, and Your Honor counted on his fingers, 5 different errors, and I believe there's even more than that. When you have cumulative error, they overlook not overlook, but I don't believe the court rules that the evidence was still strong, even though we have cumulative error. I think the courts have always ruled when there's cumulative error that the defendant at that point in time was denied a fair trial should be granted a new trial.
I think that's a little broad, Counselor. I think we've said if there's cumulative error that results in a denial of a fair trial, that would have impacted the outcome of the trial.
Yes.
That we have to impact the outcome, and if the evidence
didn't mean
is
to
so overwhelming, even if it's sloppily tried or unfairly tried, if it doesn't rise to the level that a different result would have occurred.
Well, Your Honor, I apologize for oversimplifying that, but clearly a defendant in Kansas, in the judicial system, is entitled to the Sixth Amendment right to a competent attorney. He didn't have one here, and we're here today because of that.
And what you are asking us to do is to grant a new trial for your client.
Absolutely, Your Honor. I think that's what needs to be done. And with a competent attorney that's qualified to handle these nature of charges, off-grid felonies, and tried by a judge that is conflict-free. I don't think it should go back to the same judge.
So just so I'm clear, you want a new trial with a new defense lawyer for your client and a
Yes.
new judge?
Yes.
Any further questions? Thank you, counsel.
Thank you, Your Honor.
Thank you both for your arguments tonight. The court will take this matter under advisement. That concludes